Good day everyone. Today I will discuss the Presidential Decree number 968, Section 4 to 13, as a part of final examination and non-institutional correction. Section 4, Grant of Provision. Subject to the provision of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, suspends the execution of said sentence and place the defendant on probation for such period and upon such term and condition as may deem best. Probation must be granted, whether the sentence imposes a term of imprisonment or a fine only. An application for probation shall be filed with the trial court, with the notice to the appropriate court if an appeal has right to appeal, or the automatic withdrawal of pending appeal. Section 5, Post-Sentence Investigation. No person shall be placed on probation except upon prior investigation by the probation officer and the determination by the court that the ends of justice in the best interest of the public as well as that of the defendant will serve thereby. Section 6, Form of Investigation Report. The investigation report to be submitted by the provision of officer under Section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. Section 7, Period of Submission of Investigation Report. The probation officer shall submit to the court the investigation report on the defendant later than 60 days from receipt of order of said court to conduct investigation. The court shall resolve the petition for probation not later than 5 days receipt of said report. Section 8, Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character and ascendance, environmental, mental, and physical condition of the offender and available institutional and community resources. Probation shall be denied if the court finds that. Now also, the offender is in need of correctional treatment that can be provided most effectively by his commitment and institution. D is to undue rest that during the period of probation the offender will commit another crime. And lastly is probation will be depreciated of the seriousness of the offense committed. In Section 9, Disqualified Offenders. The benefits of this decree shall not be extended to those. First is a sentence to serve a maximum term of imprisonment of more than 6 years. Second is to convicted of any offense against security of the statement. Third one is who have previously been convicted by the final judgment of an offense punished by imprisonment of not less than 1 month and 1 day or a fine of not less than 200 pesos. And the fourth one is who have been won on probation under the provision of this decree. And lastly is who are already serving sentence at the time that the substantive provision of this decree became applicable pursuant to Section 33. Section 10, Condition of Probation. Every probation or orders issued by the court shall contains condition requiring probationer shall a. Present himself to the probation officer designated to undertake his supervision at such place as may be specified in the order within 7 2 years from receipt of said order. B is report to the probation of officer at least 1 month as such time and place as specified by said officer. The court may require the probationer to A. Cooperate with the program of supervision. B. Is to meet his family responsibility. Letter C is devote himself to a specific employment and not to change said employment without the prior written approval of the probation officer. Letter D is to undergo medical, psychological, or psychiatric examination and treatment and enter and remain in a specified institution with required for the purpose. Letter E is to pursue a prescribed secular study or vocational training. Letter F is attend or reside in a facility established for instructions, recreation, or residing of person on probation. Letter J is to refrain from visiting house of ill repute. Letter H is abstain from drinking intoxicating beverage to exist. I permit to probation officer or unauthorized social worker to visit his home and place or work. J is to resides at premises approved by it and not change his residing without it prior written approval. And letter K is satisfy any other condition related to the rehabilitation of the defendant and not unduly restrictive of his liberty or incompatible with his freedom of conscience. Section 11. Effectivity of probation order. A probation order shall take effect upon its issuance, at which time the court shall inform the offender of the consequences thereof and explain that upon his failure to comply with any of the conditions prescribed in the said order of his commission of another offense, he shall serve the penalty imposed for the offense under which he was placed on probation. Section 12. Modification of condition of probation. During the period of probation, the court may, upon application of either the probationer or the probation of officer, revise or modify the conditions or period of probation. The court shall notify either the probationer or the probation officer of the filing such as applications so as to give both parties an opportunity to hear thereon. The court shall inform in writing the probation of officer and the probationer of any change in the period or condition of probation. Section 13. Control and supervision of probationer. The probationer and his probation program shall be under the control of the court who place him on probation, subject to actual supervision and citation by probation officer whenever or probationer is permitted to reside in a place under the jurisdiction of another court. Control over him shall be transferred to the executive judge of the court of first instance of that place. In such a case, a copy of probation order, the investigation report, and other pertinent records shall be furnished. Said never a probationer is permitted to reside in a place under the jurisdiction of another court, control over him shall be transferred to the executive judge of the court of first instance of that place. In such a case of a copy of probation order, the investigation report and other pertinent records shall be furnished and said executive judge. Thereafter, the executive judge to whom jurisdiction over the probationer and the transferred shall have the power with respect to him that was previously possessed by the court which granted the probation. That's all, and thank you.